That was well answered, Akinyi. Don't ever doubt yourself. Huh? You are really doing great. Okay, please let us clap for her. Thank you, mbarikiwe sana. Julene, we are being told that the recording has stopped.
On my side, it's still recording. Let me try again.
Okay. Yeah, even this side it's recording.
Okay, thank you. Let us have this. Let us have Priska. We had another hand too. Please take it away.
Yes. For my end, I would be guided by this second last paragraph that says that for the purposes of this discussion, an entry point is a provision of the Constitution that vests jurisdiction in a specified court or courts to litigate specific subject matter under the Constitution. So for me, I would go for those the constitutional provisions that create a specialized court or create jurisdiction or vest jurisdiction to specified court. Then I would go for the provision that creates the environmental and land court and discuss it. Then I would go for the provision under the article that creates the employment and labor relations court and discuss that. Then I would go for the Supreme Court, the provision that creates the Supreme Court, and what is specific or what can be adjudicated specifically within the Supreme Court. Then I would discuss the High Court. Then I would discuss Kadhi Court. Then probably I would discuss provisions relating to tribunals. Those are the ones that I would. That's how I would have approached the question specific on my end.
Thank you, Priska, for your contribution. To a large extent, I would agree with you 75%. To the extent that you have said that you will rely to the questions that will deal with the land issues. That is the provision that talk about ELC. And even you can even rush and go to even Article 40, the aspect of right to property. Okay, so you can put it together in that respect. And then maybe you can actually move forward to ELRC. Okay, then because we are being asked that we should discuss 5 avenues in the Constitution of Kenya 2010 that provide a basis for litigating constitutional questions. That is why I'm saying that maybe 70% in the sense that maybe there are no constitutional questions by the Kadhi court, and maybe for some tribunals, I wouldn't say that much, because any constitutional question that you will go to the High Court or Court of Concurrent Jurisdiction, which will mean these 2 specialized courts and the High Court. And when you mention about the Supreme Court, I would have liked you to proceed to talk about the aspect of presidential election. That is a constitutional question that court will hear at the first instance. Okay? And even thereafter, you see, when you are going for an appeal, this is something you did in your project work. So there's an appeal as of right, and then an appeal as a matter of general public importance. So when you are going on appeal as of right, okay, it means that there is a constitutional question that the Supreme Court is going to be invited to actually determine. Okay, then I agree with Akinyi when she was talking about Article 22. You can go read it together with, is it Article 250? Is it Article 256? No, not, or 259. I don't know. You need to check the aspect of public interest litigation. Okay, Mtata. So your subject matter or the way or what you are approaching the court with, it is public interest. Okay. So anything that is related to the Bill of Rights, you are going to approach the High Court, public interest litigation. Okay. That would be another issue or the subject matter that can be actually litigated at the before all those courts. Okay, you will even realize maybe for the best students she was talking. I don't know why I say she, but you see, girl child really tough, causing us sleepless nights. Sisi watu wametusahau. It is okay, we are not complaining. But you will realize graduation is coming soon, and I suspect maybe 80% will be girl child. Okay, so we are now depending with our with the wife of Honorable Rigiji. Atusaidie. Okay, so she was talking about magistrates court. So there are no constitutional questions per se before the magistrate courts, except maybe when we are trying to juggle around the aspect of Article 49 and 50, the aspect of bail, because they can give bail. One thing that the magistrate courts can't do it is to give you anticipatory bail, because that jurisdiction is a reserve of the High Court. Are we clear on this number, guys? So it was something that you can just point out, okay? Even the issue of referendum, 255, 256, 257, you just, and how you are going to explain it. Just write anything that you feel right. They will leave it, by the way. That is why we sent you that link. And if you have not been sent, then I will send it to you after this. Because you'll see something that is not the correct answer, they will leave it and they will proceed. Okay? Anyone with a question in this particular number? No question? Yes, Bwana Onyango, George.
Yes,
Yes, please.
yes. I'm learning and I'm very much grateful.
Yes.
My question is drawn at this, the last paragraph, discuss the 5 avenues for the Constitution of Kenya 2010. Those 5 avenues, what are they talking about? Is it the courts or because my argument in Uganda are based on the courts, I could have discussed about the courts.
Yes,
like I start with the Supreme Court, the presidential matters, going downward up to the perhaps magistrate court, and even the small claim court, the recently approved court, which is the small claim courts.
Okay, thank you. I agree with you on the aspect of the courts, but you see, the question is discuss 5. And by the way, you always remember this, even when you go and do your exam, what is required of you is always almost to the final paragraph. Okay, discuss 5 avenues in the Constitution of Kenya. So there are avenues, you underline that one, in the Constitution of Kenya that provide a basis for litigating constitutional questions. Okay? So, Mr. Onyango, the key word there is litigating constitutional question. So when you are about to tell me about small claims court, there is no constitutional question that is litigated at the small claim court. Some are civil claim. For example, even accidents, by the way, that one can happen. I'm actually doing one now at Machakos, small claims court. Commercial dispute, I did one here at Nairobi. Okay, so those are commercial. And you see, when Okia Mtata is going to court, you will not see him approaching a magistrate court. By the end, the only time that the magistrate court is going to deal with the constitutional question, it is when Babu Owino was arrested. Babu Owino, a question of bail was being done. So there is some constitutional issue there. But look at it, there's no, and that dispute is not of a civil nature. Okay, so the constitutional questions, therefore, are done at the High Court or courts of concurrent jurisdiction or the Supreme Court. Okay, appeals can go to the Court of Appeal. Okay, I believe if I make, am I making any sense, Bwana Onyango?
Yes.
Yeah. So if it is a constitutional question, so you are going to the High Court or a court of concurrent jurisdiction. Okay. So those, if your rights have been violated and it is related to an employment, go to the employment court. If your rights have been violated, I don't know what the county government is doing. They are taking away your land or what, infringing your right to property. Where are you going? You are going to the ELC. Okay. If it is a presidential election, you are going where? Going to the Supreme Court. Public interest litigation are done where? Are done in the High Court. Okay, Priska, I see you have a huge point you want to add.
Yeah. No. Thinking about that, the issue of avenues, which I mean, the Constitution, the avenues which the Constitution has brought about in litigating constitutional questions. What about if the Constitution specifies that, for example, when you're talking about consumer protection issues, then they say a body should be created to make effect of this, to give effect of this, maybe Article 46, and that particular body would be now be litigating. So we probably have some administrative bodies that have been created as creatures of the Constitution to determine specific constitutional question. Like, for example, the election, is it the election tribunal, right?
Mm-hmm.
Yes. Isn't that an avenue?
It could be an avenue, but even from your explanation, don't you think you are somehow overstretching, okay, for lack of a better word, because you are actually going far and further to even give meaning to some provisions of the Constitution that are saying that a body is going to be established. Because you see, it should be clear from a reading that this is a constitutional question and I'm going here. For example, when we are talking about the Finance Act, the following happened. Okiya Mtahitha stated that the bill was not, the Speaker of the Senate and the Speaker of the National Assembly, they did not sit and agree or something like that. So there were issues that he came up with, and those were constitutional questions. So where did he go immediately? He went to the High Court. Okay? So they should be things that, because here they are asking you for just 5, unless maybe when these are not 5, so then now you can go to the other one, because now you are going further and further. I agree with you. Okay? By the even the Small Claims Court, by the way, is not a creation of the Constitution. Okay? But yes, they are. It is a code that was established by an act of Parliament. Okay? So I would say sometimes just don't go further. Okay? Someone is talking about Article 40. Actually, I wrote that one in my exam. Okay? The best student talked about Article 25. Someone to look at Article 25. Okay? So, guys, that a constitutional question. What is a constitutional question? It is something, if let's say something has arisen, for example, when we are talking about BBI, that was a constitutional question. Okay? So the court has to determine this particular thing. Am I making any sense, Priska?
Yes, thank you.
Yes, please. Sawa. Can we go now to question number 4, guys, to see whether we'll meet our objective today? Meanwhile, Julene, you can scroll up and down where we can see the paper. Yes, Bona Yeko.
Yes, Kiongozi. If I was sitting this paper with you that time, I would, just as I conclude, I would have moved quickly to think about all the constitutional questions that have come to the courts, and then link them to the exact provisions that the exact provisions of the Constitution that gives those people the remedies they would go for. I would have been a bit playful to bring in the Audrey case as my 7th point, you know.
Although you have asked to give 5.
Yes, yes. I believe I write quickly, so I would write like 9 or 10. So in my 7 to 10, I would think of the Audrey case, the changing of the name, and seeing how that probably, how, of course, the constitutional provisions or rights that Audrey has that would allow her to move to a certain court to demand for her rights, plus any other thing, of course, the question of the basic structure and the question of referendums, yeah, as you've said, insofar as the Constitution is concerned. Of course, the right to property. I would also look at the rights of the marginalized, like the Chamus. I would go ahead and, yeah, that would be my line of thought from point 7 to 10. I don't know if I would be still on the right trajectory. Thank you.
Yeah, I think you will be on the right track, but I would hope that you'll give your first best point. I have seen someone say that they mark the first 5. Actually, they look for you. They look for marks for you. That is why I was saying just write anything that you feel is right. The examiner will choose what to leave. If you see them like from the side, they are just moving, no tick, just know that that particular person has written nothing there. Although they felt at the time that they wrote something. And then there inside, you will see some tick marks going. So they look for you. This is correct, this is correct. They will proceed. Okay? But just always give your best point first, and then you proceed to the next. In any event, they will still go and find some marks for you. No one want anyone to fail. They just want you to pass exams. Okay? So thank you so much for your contributions. Again, Makofi, as someone is, please clap, Bana, and don't leave bad of time. Okay, we still have some time, guys. I'm seeing our number is reducing considerably. Okay, let's now go to question number 4. Is it someone raised his or her hand a few seconds ago? Please read that question. Unmute.
Good evening. Question 4.
Yes.
James filed a suit against Mla Leo, a teacher employed by the Teacher Service Commission for the recovery of a sum of 2 million Kenyan shillings at the Chief Magistrate's Court. The judgment was issued in his favor. James extracted a decree from the judgment. Mla Leo was in court when the judgment was delivered. He sought a stay of execution for 30 days, which the court granted. It is now 3 months since the date of the judgment. Mla Leo is yet to pay the decretal sum. James has tried to accommodate Mla Leo by asking him how he intends to pay the decretal sum, but Mla Leo is non-committal. James has even paid Mla Leo several visits at his farm in Ngong, which he owns, but nothing is forthcoming. Zakaria, a colleague of Mla Leo, has informed James that Mla Leo's salary is usually paid through an account at KCB Bank, Ngong branch, and he is certain that Mla Leo has at least 500,000 shillings in that account. Mla Leo even bought a motor vehicle in the recent past for personal use.
Scroll down, our DJ.
Advise James on the 5 possible ways through which he can recover the decretal sum from Mla Leo.
Very good, very good. Thank you so much for raising that question. Again, like I said before, stop there. Look, you have been told advise James on the 5 possible ways through which he can recover the decretal sum from Mla Leo. So that is what is being required of you. So even the all of that story, okay, it has sense, it is directing you, but what are the forms of execution? That is what you are being asked here. To be sincere with you guys, this was the only question that I believed it would, maybe if I was to get 9 P's, this was one of them, because I said even if I fail everything else, this one I will have some 10 marks or even 5. So if I can get 9 plus 1, say that I can get 10 P's. Unfortunately, I left there with 9, but it is okay. I still have some time, okay, to get the 10th P. It is very, very important, that particular P. So you are being asked to advise him on those possible ways through which he can recover. So maybe we can have, maybe one person can give us 2. And by the way, I don't know if your lecturers have told you, they always have a question on execution. I don't know why. Or is it because it's where there is money? Because litigation without execution, there's nothing. Because it's from litigation, that is where you get paid. Okay? If you look at all those questions, by the way, something related to judgment, ruling, execution, these are most of the time, maybe you will not cover them. Please read on execution, on judgments, on rulings, okay? So can someone please give us, we have about 7 of them, so that we can move really fast. Unainua tu mkono kama umesema moja, mwenzako anasema hiyo ingine. What are these forms of execution, please? Na explain kidogo, tunasonga mbele. Hata mimi nilikuwa na explain kidogo. Ukiingia kwa examination room, unasahau, nilikuwa najua hata orders. Nilikuwa hatari. Lakini ikaenda tu bado. Yes, Onyango. Okay, we have Onyango.
Yes.
And yes, tupe mmoja mwingine.
I think this one is provided for under order 22 or 23, if I'm not wrong. One of them is the attachment and sale of maybe the property of the defender, the judgment data.
So you are saying by attachment and sale?
Yes.
Or by sale without attachment of any property. You see that is a point on its own.
Oh, okay.
Yes, it is okay the way you have said. So it is by attachment and sale, or by sale without attachment of any property. So that is one way of execution. So even that particular property, so you can attach or you can sell. That is very good. Thank you. We go, the second person was Anne. And then Jerry, please put your hand up. Yes,
Good
Anne?
evening. So
Yes,
I'd say there is attachment of salary where a court will make an order attaching, I think it's 1/3 of the salary of the judgment debtor. And now the employer of this judgment debtor therefore should just deduct 1/3 of the salary. And I think, I'm sorry, I can't remember the name of the previous person who's just spoken. I don't know if it's sale without attachment of the property, where the property is sold through a public sale via an auctioneer who's appointed by the court. Yeah, so I think there can be sale without attachment. I was just expounding on that.
Okay, thank you. Thank you very much. Another person, please, Mukuna Njeri.
Okay, I wanted to explain about garnishee proceedings, which she has. Then I think another way that we can do this is through, if there are no means, we are unable to recover through any other means, we can make an application for committal of this person to civil jail for a period of 6 months.
Very good. Section 38 of the Civil Procedure Act. Committal to civil jail. All right. Kalea Janita, tafadhali, proceed.
So attachment of property, and the property is the car that he bought recently.
So that is attachment of movable property.
Yeah.
Because there are 2 points, and that is why I liked it. That is why it was easier than getting my 10th P, in the sense that you can attach movable property, that is 1 point, 1 mark or 2. Then you can attach immovable property. Okay, so you see, those are 2 points already. You can attach movable property, you can attach immovable property. Okay, yeah, someone is saying delivery of any, that one is something that raise your hand and tell us. Okay, someone had raised their hand before Kalea, Janita, someone had raised their hand. Onyango?
That was an old hand, sorry.
Okay, okay. So guys, they are as follows. So number 1, it is by delivery of any movable property. Okay, specifically decreed. Number 2 is by attachment and sale, or by sale without attachment of any property. Number 3, attachment of debts. Number 4, by arrest and detention of any person that is in prison. Number 5, that is by appointing a receiver. Okay, you can appoint a receiver. There is attachment of immovable property. Okay, there is attachment of movable property. So warrant can be issued to a licensed auctioneer, that is pursuant to section 14 of the Auctioneers Act. Okay, then appointment of a receiver, that is pursuant to order 40. All right, so I believe I can reiterate that please still proceed and go and read on execution, on judgment, those units that you will most likely not cover. A question always comes in those areas. Yes, Ms. Akinyi.
About payment in installments.
That now becomes part of out of court settlement, or that is arrangement that you can try to reach with the judgment. Is it called data? But it hasn't been provided for.
Okay.
Yes, thank you. Yes, Priska?
There's this question that came up by orals, and I don't know whether it is related. I was asked, how do you enforce professional undertaking? So you've entered into a professional, there's a professional undertaking in place, and then the person.
Mm-hmm. How do you enforce the professional undertaking? It is not relating to this one, okay. But I have forgotten. But there are 2 ways of which that it can be enforced.
Okay.
Yeah, and I believe the first one, it is. I don't know. I have forgotten, but there are 2 ways. Let me get back to you on that. Yes, Anne, you want to answer that question?
Yes. I'd like to give it a shot, if I'm not wrong, because professional undertaking is it's binding and legally enforceable. I think it's usually enforced through the courts.
Yes, it is. It is.
No, I said it is enforced through the courts. Then the lecturer was like, of course it's through the courts. Speak like a lawyer. Speak like, go to the civil procedure rules, So the thing of saying that it's enforcing, he was not satisfied with that answer. It was like, you need to go further. So I thought, is there something that I didn't say? Like just saying it's enforced in court, he said verbatim that you're speaking like a layman. Of course it's in court. How do you enforce it?
Okay, let's hear. I can see a lot of hands here. Take it away, where you see.
A PU is enforced through Order 52, Rule 7, and that is by taking an originating summons.
Okay. All the hands have dropped. Momanyi?
Appeal is enforced in two ways. That's under Order 52, Rule 7. In an existing matter in court, it can be exposed, it can be enforced by way of chamber summons. But if it's a new matter, you have to file an originating summons. I think that's what that question was.
Okay. Someone hands was up. Anyone who have something to contribute to that? Okay. Thank you.
No, I think the question that Dalmas is answering, I'm not sure. I think you're talking about interpleader, where you when it's an existing matter or a matter that is new, where you do either chamber or an originating summon.
Yeah, all right. Sure. Let's do this. Okay, Rita.
Good evening. Dalmas is not really talking about interpleaders. Interpleaders are in Order 34, but when you look at Order 52, Rule 7, it's very clear that if there is a pendency of suit, use chamber summons, and then if it's a new, of course, matter, if it's a new suit, you will use originating summons plus a supporting affidavit. So that's how you enforce at the High Court. So he's correct.
Okay, thank you.
Okay, thank you. I will get back to you with an affirmation, Priska. All right. All I know is that it can be enforced in two ways. Okay. So now, guys, now we have done 60% or 80%. What is the time? We still. So now, what you will do, Otieno? Let's go to question number 6. Then we'll come back to question number 5. Yes, someone read that question, please.
I could go. The Republic of Kiza has a constitution and standing orders like those of the Republic of Kenya. Musa is a sitting elected member of parliament for Umbea constituency within the said republic. On 31st November 2022, Musa was in attendance in a joint sitting of parliament during the State of the Nation address by His Excellency, the President of the Republic of Kiza. Musa on several occasions during the sitting raised points of orders to draw the attention of the President on the suffering of his constituents. He did this pursuant to his constitutional right to picket, as envisaged under Article 37 and the right of his constituents to representation. The Speaker of the National Assembly, in utter disregard of the provisions of Article 201 of the Constitution, unlawfully ordered Musa out of the National Assembly without according him an opportunity to be heard. His attempts to catch the attention of the Speaker to explain himself were unlawfully and unjustly construed as disobeying orders of the Speaker. The Speaker invoked the provisions of the Standing Order number 111 of the National Assembly and suspended him for the remainder of the session. The Speaker disregarded clear provisions of the Constitution, laws of natural justice and fair administrative action. He publicly declared that his decision was final and would not be rescinded, and that Musa would not be given any room to appeal against the decision to suspend him. Attempts by Musa to explore internal remedial measures to get justice have all been frustrated. He has effectively been barred from accessing the precincts of Parliament and cannot therefore discharge his constitutional duty of representation to the prejudice of his constituents. Musa has approached you to challenge the decision of the Speaker. Write a legal opinion on the nature and scope of the pleadings you will advise Musa to file to successfully challenge the decision of the Speaker. 10 marks.
Very good. Thank you so much. This was also one of the easiest questions maybe the Lord gave unto us. So now let's examine it together. Okay. So maybe someone can raise their hand, please, as we try to juggle around with this particular question. Someone quickly. Proceed, Almas. Proceed.
Simply, I think the question is on judicial review, so that if we have to look at the pleadings that are needed, and under Order 53 of the Civil Procedure Rules, I think now we have to go through the two stages. The first stage being the leave stage, and the following stage, which requires a notice of motion that should be filed 21 days after leave is granted. The pleadings will be filed at the High Court. I think those are the things we need to look at. Thank you.
Okay, thank you, Dalmas. Anyone else? I saw another hand. Yes, Priska.
I would go for a constitutional petition.
Mm-hmm.
I mean, a petition as the pleading. And within that petition, some of the prayers would be judicial review prayers. That's under the, I don't know which article is that allows, that provides judicial review as one of those prayers. I mean, remedies that you can seek within the Constitution, because it's saying pleading. I think I would go with a petition. I would advise him to file a petition as the pleading.
Okay, thank you so much for your contribution. Who else? Someone, I saw another hand before. Yes, Anne, take it away.
I agree with Dalmas. I'd go with what is it called? Judicial review, and I'd approach the court through a notice of motion and what is it called? And a supporting affidavit. Yes.
Okay. The next person, is it Onyango?
The last speaker has said what I wanted to say. I support Dalmas. It is a judicial review under Order 53 and a notice of motion supported by an affidavit. Thank you.
Okay. I believe this is where I come in now, if there is no one else. Sawa, kama mwalimu, mimi ndio wa mwisho. So now, you see in this particular question, it wasn't asking, let's say, one specific thing. Huh? So you have been asked, as a council working, the question is, Musa has approached you to challenge the decision of the speaker. Okay. Write a legal opinion on the nature and scope of the pleadings. You will advise Musa to file to successfully challenge the decision of the speaker. Okay. The speaker, parliament, okay, quasi-judicial, all those, okay? So there were two things that I understand there, it is saying pleadings, but although judicial review application, people say it is an application, it is not a pleading, but how do you challenge a decision of a body or a person like the Speaker of the National Assembly? So for me, I would go with two ways, okay? So he can challenge the decision of the speaker by filing a constitutional petition, okay? Pursuant to Article 47, fair administrative action, the aspect of right to be heard. Now you can quote all those, Article 20 what, Article 20 what, okay? So Fair Administrative Action Act, all right? Because of the decision of this particular speaker. Those that would be, because you are giving a legal opinion, you can, that would be one, because you are giving someone options on how he or she would handle this particular constitutional question. Okay, so I would advise him that he can challenge the decision of the speaker by filing what? A constitutional petition. Okay, pursuant to Article 47. Okay, sections 11, or is it 11 and 12 of the Fair Administrative Act? There are those sections that will quote from the Fair Administrative Action Act. Okay, so if that would not be enough, or you can give him another one, that he can actually challenge the decision of the Speaker of the National Assembly by filing a judicial review application. Okay, this one, it is the traditional way. Okay, so what will he do? He will go approach the court. The procedural aspect of it is under Order 53. Sections, is this sections what of the Law Reform Act 7 and 8, or is it 7 and 8 or 8 and 9? You can look at it, okay? Or of the Law Reform Act, okay? Such that you can go, you can tell them that they can seek the leave first, and thereafter they can file their substantive motion. All right, so you can give him those particular options for him to challenge the decision of the Speaker of the National Assembly. I don't know if I am in order. Any question? Yes, Anne, please, and then Dalmas.
All right, I have a question. You've mentioned that if we were to go with a judicial review, we'd have to say that at the leave stage, we'd have to approach through a certificate of urgency. Then would we have to include the things like the chamber summons, the statutory statement, and the verifying affidavit? And also another question is, if we still go through with a judicial review option, will we have to further emphasize that we are seeking the three prerogative orders, the mandama, certiorari, and the order of prohibition, or where do we leave it at? Is it okay if we just expounded that in that manner?
These are good questions, huh? You see, you are giving someone advice, huh? So sometimes even when you are telling them about the certificate of urgency, chamber summons, applications, statutory statements, and all those, I believe when you are seeking leave, you are supposed to file close to 4 documents, okay? And then the final one will just be filing your notice of motion application. Others have argued that you are supposed to file together with the supporting affidavit, which has not been provided for, but you can give a copy of that particular verifying affidavit. You are supposed. The difference is that the verifying affidavit in the leave stage, you need to have it detailed, because there is no another way that you will be able to introduce some evidence in this conundrum. Okay. So, and on the first part, yes, you will tell him that because of the nature of the urgency, you need to represent your constituents. You have been locked out. Yeah, you have to go under certificate of urgency and all the documents that are supposed to be filed together when you are seeking leave. Okay, and in this regard, I don't think prohibition would be one of the prerogative orders that you will seek, but I am quite sure that you would want that decision of the Speaker to be quashed, and you will also want that particular Speaker to be compelled to do something. Okay, the aspect of prohibition most of the time comes in when you are being prosecuted or something like that. So you want that particular, maybe the DPP or the DCI or the Inspector General of Police to stop, okay, to be stopped, to be prohibited from prosecuting you or something like that. I don't know if I have answered your question, Anne.
clear as day. Thank you.
Yeah. So in this regards, you will have those constitutional provisions. Okay. So since it is a legal opinion, you will begin by giving your introduction. Is it FIRAX? You're giving the facts, okay, the issues. Then you will proceed and give your analysis, and then you will go and contribute and conclude. Sorry. Dalmas, did I answer your question because your hand was up to?
You did partly, but I agree with your position that we can file either of them, approach the court through a petition, or the old way under Order 53 and Sections 8 and 9 of the Law Reform Act. But then I'm looking at this question from the angle of urgency. So that my question is, can we then bring the question of urgency in and then take the route of a judicial review application under Order 53? Because I think the question is saying that the continued disbursement of Mr. Musa from Parliament is prejudicing his ability to discharge his role and obligation to his constituents. Could we use that as a ground to take one route of another?
I believe we can. However, you see, even in a constitutional petition, there are some interlocutory orders that you can seek. You remember, like, the good case is the Finance Act. You see, a petition has been filed. Now it is being determined at the High Court, Constitutional Division. But Honorable Okiya Mtata went ahead and filed a notice of motion under certificate of urgency, seeking inter alia to suspend the operation of the Finance Act, and actually he succeeded at the High Court. So you see, even if you are going by way of constitutional petition, you can accompany your petition with your application for some conservatory relief. Okay, so now we are not seeking injunction because it is a constitutional petition, but you will be seeking some interim conservatory orders. Okay, because those are things that have been enlisted under Article 23. Okay, so you can seek for those conservatory orders at the interim, and later you can equally seek them in your petition at the end as your prayers. So even if you are filing a constitutional petition, you can accompany a constitutional petition with an application seeking conservatory orders at the interim. Okay, is that right, Dalmas?
That's okay. Thank you so much.
Very well, very well. So guys, what time is it? Okay, so maybe quickly, Honorable Julene Otieno, maybe you can take us to question number 5. Question number 5, it is a short one. So that one, the best singer that the Kenya School of Law has ever had, please take it away. Nako na sauti tu mzuri, si kama hii yangu. Someone.
Mimi ama.
Ayeko. Sawa, kama unajiaminia. I believe there was one that ulikuwa unasumbua alikukataa, but ni sawa tu. You will finish that with 9 P's, my friend.
Sijaanguka hiyo mtihani in the past, but let us focus on this other one here, CLE. So question 5, in Muiru General Store versus Attorney General and another, High Court of Kenya at Nairobi Civil Case number 1603 of 1971, bracket 1972, KHCD number 104 of 1972, the plaintiff claimed special damages for the loss of their vehicle which was wrecked after colliding with a GSU lorry. The defendant, despite requests by the plaintiff, withheld photographs and sketch map of the scene of the accident until a later stage in the hearing. The court decided on the weight of the evidence that the driver of the plaintiff's vehicle was wholly to blame for the accident and dismissed the suit. After receiving judgment on the issue of costs, the court remarked that although the defendant had no legal obligation to supply to the plaintiff the photographs and the sketch map, their conduct led the plaintiff to think that they had a good cause of action, hence the suit. The court therefore invited the defendant to show cause why they should not be deprived of costs. As a counsel working for the defendant, draft a legal opinion explaining circumstances under which a successful defendant will be deprived of his costs. I think the examiner was not gender sensitive. Thank you.
That is all right, guys. This is our final question. So I'm really praying and hoping that you will bring your A game so that we can brainstorm. Okay. So maybe as we conclude, maybe we can finish this particular question on higher note. Let's have about a few contributors. Please raise your hand. Tafadhali. As a counsel working for the defendant, draft a legal opinion explaining circumstances under which a successful defendant will be deprived of his costs. As you remember, we have the principle, cause follow the event. So in the sense that if you have won the case, so it means that you shall be awarded costs. Okay? Cause follow the events. Why now, if you are a successful defendant, you will be deprived of your costs? We have two persons, that is, we have George and Priska. Okay, George, you will go, and then Priska.
Okay, thank you. My understanding on the question is one, legal opinion. We shall follow the procedure as we had done before. But as we've said, and as the law states, the successful party always get the cost of the suit. But there are some exceptions to that rule, in that one, where one can be denied the cost is if the matter is of general public importance. Like I'll give a case of the presidential election petition. Since 2013, no party has ever been given the cost of the suit. Second, if the yeah, I'll stop at that because I wanted to talk about failure to supply a demand notice or a demand letter, but I think I'm answering the wrong question. Thank you.
That is all right. You are giving correct answers to a wrong question, so there was nothing wrong with that. Your answers are right. It is the question that was wrong. Okay. So now let's have our next contributor, please. Priska.
Oh, my hand has gone down. I was thinking of answering it generally and saying, outlining instances whereby a defendant might be deprived of the cost. And one is what George had already said about public interest litigation. So in public interest, and there are many case laws that state that when it's public interest litigation, then the court can give no orders as to cost. But now you are saying we are answering the wrong question, so now I'm a bit confused.
Oh, no. You were saying the aspect. I was talking about the aspect of demand letter. It was not related to this one, because you see, demand letter, it is the plaintiff who writes the demand letter. It is not the defendant. So his answer was correct, but the question was wrong.
Okay, so that was my only point then.
Very well, very well. So,
okay, I'll add another one.
Yes.
The conduct of the party during the proceeding. I think maybe if the party, the defendant side, their action like provoking the judicial, the judge or the magistrate during the proceeding, then they can be denied the cost. Or maybe if you are served and maybe you never attended, maybe ulisumbua hapo katikati, then I think you can be deprived the cost of the proceeding.
I like that. I like that. Let's hear what Anne has to say. Anne?
Cool. Hi. So I don't know if I'm overthinking, but I'd say that the reason why a party would be denied costs is based on if the parties were not precise in filing and drafting of the pleadings, and be guided by the Anita Karemi case, where it was stated that the court cannot grant what is not pleaded. So I think I'd have gone with that.
Okay. Anyone else, guys? George, your hand is still up?
That is an old aunt, sorry.
Because you see, when determining the cost, okay, Barak, please. Barack Obama?
Yes, yeah, I wanted to suggest maybe the question of whether the cost is reasonable. Yeah, and when looking at reasonable, maybe was it reasonably incurred, or is it of a reasonable amount? And in some cases, they look at the 7 pillars of wisdom to check what is reasonable. Whether the conduct of the parties, as someone has mentioned, the skill employed. I think I'll have to check it again, but I think there's something to do with reasonableness.
Okay. So guys, these are some of the things that are not taught at Kenya School of Law, but we survive nonetheless. Alice, please contribute. And then the next one, your hand has just disappeared. The next person, please put your hand up. Yes, Lois. Yes, Alice?
Okay, mine is an attempt. I'm thinking costs are discretionary. So it is the discretion of the court to decide whether they are going to award the defendant cost, whether they have won or lost.
Okay, let's hear what Lois has to say.
Yeah, I wanted to point the law that speaks to cost. It is section 27 of the Civil Procedure Act, and I will support Alice. It's a discretion of the court to determine whether to give a successful party the costs.
Very well, very well. So it is a discretion, costs follow the events. All right, I agree. So anyway, guys, I would just like you guys to go and maybe read this one authority. It is called, I will try to type it here, but I can't type real slow. It is called Jasbir Singh Rai and others versus Tarloshan Rai and others, 2014. EKLR. It is a decision of the Supreme Court, because it is just like, you see, it is trite law that courts follow the events, in the sense that the successful party at the end of the day must do what? Must be awarded costs. But you see now in public interest litigation, court will always decline to award costs. They will even go further to state that there are no orders as to cost. Okay. However, having said that, you have to look at what are the circumstances of that particular case. Okay. For example, some of the circumstances or consideration that the court must consider when dealing with the issue of the cost are as follow. Number one, the conduct of the parties. Number two, the subject of litigation. Number three, the circumstances which led to the institution of the proceedings. Number four, the events which eventually led to their termination. Number five, the stage at which the proceedings were terminated. That is, if, let's say, an out of court settlement was reached or something like that. Then number six, we have something called the manner in which they were terminated. Now, then second last, something called the relationship between the parties, and then the need to promote reconciliation amongst the disputing parties pursuant to Article 159(2)(c) of the Constitution. So, like as it always been, there is a general rule and there are always exceptions, because costs will always be awarded to a successful party, but in some instances, that would not be the case. Okay, for example, in the aspect of public interest litigation, there would be no orders as to cost, and if or when, let's say, the costs are awarded, you will hear the court pronounce themselves to this effect that parties should bear their own costs. Okay, parties should bear, or parties to bear their own costs. Okay, so I will just type maybe these two authorities, that authority of the Supreme Court of Kenya, and then the High Court of Kenya. Okay, so then this would conclude. I can see there are two hands. There are three hands that are up. Lois, okay, thank you. Esbon Oko, senior litigator, almost best student in civil litigation. I'm sorry, my lord, but please proceed as I type the case.
Okay, thank you so much, Angel. I've actually listened in. Before you came in, I wouldn't really belabor in reiterating whatever you've said, because you've clearly mentioned, and I think that the person who came before you also scored it right on the issue of cost. So guys, this question was just testing your understanding of, first of all, what you understand by costs, and if how you know how costs are dealt with by the court. So you realize as a person who came before Angelo already got it, that costs is actually provided for in section 27 of the CPS Civil Procedure Act, and clearly there is no mathematical formula when it comes to costs, and that is why we call of a discretion. It's upon the discretion of the court. Angelo has mentioned 6 factors which the court will have to consider before the grant of costs, and that was the answer to this, because you can actually clearly see from the second line of this, the fact file. The plaintiff claimed special damages for the loss of their vehicle, which was wrecked after colliding with the GSU lorry. The next line says the defendant, despite request by the plaintiff, withheld photographs and sketch map of the scene of the accident. You see, so already you can get to understand that there was already a frustration on the side of the plaintiff. The defendant was frustrating the plaintiff. So clearly the court will have to look at that, because you remember, you see the thing of cost, like the cost starts immediately you receive instruction by from the plaintiff, the client interview. So the court really considers all those steps until when judgment is being rendered. So if the court establishes that one party was really maybe frustrating the cause of the course of justice, or rather the course of administration of justice, then judicial exercise of the discretion of costs will then mean that that person be denied. So that is just one among the 6 factors that Angelo did discuss so well. So about that question, that is exactly what the question really just wanted. Then, of course, you all understand the format of the legal opinion, and then the rest is just the issues which are easy to be discussed. So maybe, Angelo, we can pose a question to the team if they have any in respect to this, but I believe you have really tackled so well the question. And then you have mentioned one case. It's actually important. I also had one I wanted to come up with, but I noted already, let's not bombard them, but just in case someone can go read the case of Cecilia Karuru Ngayu versus Barclays Bank of Kenya and another. It's a 2016 decision. Cecilia Karuru Ngayu versus Barclays Bank of Kenya and another. There's a very serious discussion of what cost is, what the courts will have to consider before the grant of the same, and just a direct answer to this particular question. Thank you.
Okay. Thank you so much, Esbon Oko. I can see there are 2 more hands, one from Belarus and another Kalea. So Lewinsky, please, let me check first. Okay, we have a few minutes.
Mine is up.
Okay. Yes, proceed. Then Janita.
Mine is a question. I just wanted clarity on the format of the legal opinion, on whether after you've drafted the whole content, when you sign it, do you also include that part whereby you say drawn and filed by so and so, or a legal opinion only ends at signing off that you've signed, then you say Lewinsky Muhira of this particular firm?
Okay. Mr. Angelo, can I proceed? Or?
Yes, please proceed, my lord.
Okay, so thank you so much. That's a very good question, and seeing that we are doing drafting part, that is the most important thing. They'll be looking at the format of every document you do. So get this formula that when drawing pleadings or documents, you can actually divide them into 2, or actually into 3, so that the first documents will be documents you are drawing to clients, like documents solely made for clients. These are clients who walk into your office having a legal issue and they want maybe an advice, like for example, the present case. So they just want you to give a legal opinion on that particular issue. So whatever you will do, you just do the legal opinion, whichever format you've been taught, but I understand the FIRAC is usually used. Others will say CRIAC, but most of the people really use FIRAC. I understand that is the format we were taught. Then you sign off. It is like just sign off. It is yours faithfully. Then you sign off. Just that. Then if it is that is a document to the client because he's seeking an advice on something. The next document can be, for example, the demand letter. You see, the demand letter, you have been instructed by a client, but you are writing it to someone else. The legal opinion, you are writing it to that person who instructed you direct. So you'll just sign off. But this one, demand letter, you're writing to another person on behalf of that person who has instructed you. So that on signing off, it is important you sign off and then you CC client. The CC part is very, very crucial, and there is a marking point at that point. So you see, at that point, you don't have like filed and drawn, because these documents are usually done before, it's actually pre-litigation stages, or it could be during, but the same do not go to court. So it is not, you don't indicate like drawn and filed. Then, so those are like the documents you will deal with clients. Then now, in the course of litigation, there are documents you will draw that they are going directly to the court. For example, pleadings. Let's say an example of, I saw you, I think, drafted a plaint could be the first question. So you see, when preparing the plaint, much as like you'll have to serve the other party, the interested person or the interested key player is the court, so that you have to have this document filed in the court. So that is why after you sign off as a firm, like after, for example, dated at this, dated at Nairobi this dash day of 2022 or 2023, then you indicate down there, for example, if it is Angelo Ooko, advocate for the applicants, then you now indicate, you show like who drew this document, because you are taking it to the court. The court needs to understand like who drew the document. So that is where, at that point is where you show that it was drawn, and then it's being filed in this court by this firm. Then you indicate the name of the advocate or the firm of the advocate which is drawing and filing that document. Then remember, as you draw that document, the rule of natural justice, that you cannot be heard, you cannot be condemned unheard, so that you must get to get the other person informed of what you're doing, so that the pleading that you file in court serve upon the other party. So that is where you have a section of saying served upon, then you serve upon the individual, or if he's already appointed advocate, you file, you have it upon the advocate. So that will be the document that will contain drawn and filed. But for this legal opinion, demand letters, those are just, you are taking it to individuals. So you don't do the drawn and filed and the one to be served upon. I don't know if that is clear. Maybe I will take
that. That is very clear. Thank you.
Okay, you're welcome.
Okay, thank you, my Lord Ooko. Janita, please take it away.
I had a question for Hezbon. He mentioned an act under the CPA, the Civil Procedure Act, for costs. Could you please repeat that again?
Sorry, you are asking about the section, right?
Section, yes.
Yeah, yeah.
Section 27 of the CPA, section 27.
Okay, thank you.
You're welcome.
Yes. All right, Barack Obama, I believe you are the last person.
Yeah, okay. Thank you. I just wanted to know some basic aspect. Is it really important for me to distinguish between a pleading and an application? Is it very crucial that I know the difference, or I can just be using them interchangeably? Those two terms.
Okay, all right. You see, Barack, at the very beginning of your civil litigation, this should be the first thing that you should know about the distinction between the two, because they are not one and the same thing, and you cannot use them interchangeably, at least as of now, at the Kenya School of Law / CLE. Okay, because applications will refer to those things that we will do when the suit is ongoing. For example, we drafted one application before, that interlocutory injunction. That one is an application. Okay, but pleadings, they include the plain. Okay, they include the petitions. All right, so it is really, really important that we distinguish between applications and the pleadings, because they are not one and the same things. But when you will come out here, I don't want to mess you up, but maybe upper India, there's something that we just call them pleadings anyway. As Bon, I can see you have something to add. Please proceed.
Yeah, yes, I have something to add for our good brother. So now, if you want to understand, or rather to differentiate between what an application and a pleading is, an application. First, let me just categorize these. That all these are ways in which, or rather, ways in which you want to approach a court. You want to make an application to the court, or you want to prepare a pleading to the court. So you may be in two situations. And I'll give you a situation so that you understand better. Let's say, for example, you have a parcel of land, or you've been staying in a parcel of land for 5 years. Then there comes a person who now wants to evict you. So in that situation, you can actually approach the court using various documents. So first of all, because the eviction is imminent, you need to protect yourself from the eviction, so that you are interested in some orders, like, you know, the orders of the court. I want to get these orders of the court so that I do what? I get protection. So in a situation where you need orders by the court, you make an application. You need orders of the court, you make an application. For example, you need your matter certified agent, an order certifying your matter agent, you make an application. You need to stop someone from doing something, for example, an injunction granted, that is an order, you make an application. Then at what point will you need a pleading, and how will you know you need a pleading? You need a pleading when you want the court to hear a matter with finality, looking at the merits of the issue. For example, in this issue of land with eviction, the aspect of the eviction, you just want to be evicted. You are seeking the orders through the application. The court will give you those orders without having without having to listen the merits of the disputes between the person who's seeking to evict you and yourself, of maybe who is the rightful owner. So in the application, the court will just grant you the order or the orders, so that the suit, now the main suit you'll make, is not rendered as useless. So you'll make application to have the orders, and then you'll now make a main suit. That is why you see, for example, if it's an adverse possession, you proceed to make an OS, or you can proceed to make a plaint, so that you now seek the court to find you as the owner of that land. You seek permanent injunctions. You'll be declared as the owner. So for you to be declared as the owner, the court will have to go through the merits of all the issues that you raise. And that is why now, in pleadings, the court is going to hear the finality of the matters. In application, the court is just going to grant you orders, even without getting really to, as long as the court establishes that there is something to be discussed here, they'll give you the orders. So that is actually the difference. And you realize most application, you did them by way of notice of motion through by dint of Order 51, Rule 1 of the Civil Procedure Rules. Then for pleadings, they have or various sections of the law which you'll rely upon. So as Angela was telling you, pleadings can be petitions, defense, plaint, and whatnot. You can name them. But for applications, most of them notice of motion. But it can actually exist, for example, OS as a notice of motion. So I don't know if that will maybe bring a clarity, but that is it. Thanks.
Yes, Bwana Barak, I believe you have understood, in the sense that applications are meant to address an issue pending the hearing and determination of the main suit. Okay, so anything that will happen in between here, be it just like the way Esbon has described, those will be applications. But outside here, we just say, you know what, we have seen their pleadings, we received their pleadings late, but when you look at what you have received, actually it is an application, or someone was responding to an application. Okay, but it is good that we distinguish the two. I don't know if you have been answered well, Bwana Barak.
Yes, very well. The point that you've just mentioned last is what normally brings that conflation of issues, because you find the word pleading is used very carelessly, so to speak, and it causes a bit of confusion. What also adds to that is a notice of motion application, because whereas they are applications, but you find in certain cases they are used to approach the court. I don't know whether there is an exception for this.
Yeah, you would say that way. For example, when you are filing, let's say, a bill of costs, okay? So you are using, it is a miscellaneous application. So if it is a miscellaneous, so it is something that is there, it is a suit and it is not a suit, it is an application, it is not an application. But remember, we don't use notice of motion application for bill of course, okay? Let me not take you there. But you realize sometime when we are appealing some of the decisions, we use notice of motion application, okay? For example, if you are appealing, you want a stay of execution, you're at the Court of Appeal, you realize that you will use what? A notice of motion application. But just understand it barely as we have just explained. Okay, I believe, guys, do we have any other question? So that we can conclude our talk for the day. We are left with 3 minutes. Okay, Esbon, you have any last word you can tell them? I don't know when next we will meet them.
Yes, thank you. 30 seconds or 30 seconds to my colleagues. This is my advice to you, by the way. As we go through these papers, I know maybe some of you, or maybe all of you are smart enough that you're just picturing how a notice of motion appears in the head. It is true, you can actually do it from the Republic of Kenya until Uko Mwisho, the penal notice. But that is just in the mind. But you'll realize that when you are now given a question and asked now draw it and you're alone, it may be very difficult. So the solution to this is, and as you start your third term, third term is actually all about practicals, so that you just drafting. So just ensure every day before you just have a list of all the drafts in civil, and you don't have to have all the draft. You realize they don't even set all these things. They're just key drafts that you need. The petitions, the plaint, the JR process, all the JR process documents, the defense, and especially the defense, I'll insist on it, the replying affidavit, how the supporting affidavit appears. So every day, just draft it. Just draft one document. You can have your colleague just to go through it. Just ensure you draft handwritten. Just draft it. Trust me, if you do that for continuously 2 weeks, you will find these things very, very easy, and you'll take a little time, even in exam, to draft this. If you don't, okay, like you may exactly know what you need to. You need, for example, you need to draw a ruling, but it can even take you 1 hour. You see, you may not have that luxury of time. So my advice to you is that kindly just be practical in this. Just handwrite that those drafts and have them down, get to understand how they're done, and you'll be good. Meanwhile, Angela will give you direction. We may meet you maybe in a month's time or so, just as we shall be directed. Thank you so much and have a good night.
All right, thank you, Honorable Oko. Thank you guys for contributing. It was a great experience for me, and to be able to assist. I hope we have contributed however we can. And just to say this, because these are critical times, because sometimes other people will say that it is a life-defining exam. Of course, we agree, but don't be pressure much, because what CLE wants is no pressure. What CLE wants, it is you to be calm, for you to revise, and for you to do whatever you have to do to pass the exam. Sometime to be smart, okay? Because not everything that we read will come in an exam, but you at least want to know that there are 6 questions. You cannot be that bad in all 6 questions. So what I'm trying to say is it is not a matter of life and death, but like in law, it is also a matter of life and death, okay? So it is how you prepare yourself that will matter. Don't listen to what people say, even if they have read, I don't know for how long. Don't listen to them, just do you, okay? By the practice, make perfect. Okay, for me, when people were crying that they have not finished the paper, I asked them, what do you mean? Okay, because I always have even some time to relax and maybe look around, because that hole is too huge and there are CCTV cameras, not CCTV cameras per se, but people standing, these invigilators. They are actually more vigilant than the big brother. Okay, so even when you are looking maybe to support someone, because it's the first time that you will see a lot of people. I have started with 200 people, but not when the hall is full of a huge number of people. Then you tell yourself, this is a lot's work. I'm going home with that 10p. Okay, so you look around, okay, then maybe the invigilator will say, no, this guy wants to steal exam. So what I'm trying to say is just, when you are bored anytime, tafadhali, just drive a plane, just drive a notice of motion application. No, how do I start a certificate of urgency? How do I start a chamber summons application? How do I start a notice of motion application? How do I start an originating summons? You see chamber summons and originating summons, you will try to interchange those things. But with practice, this is something that you can do. It is something that can happen. Those last 2 weeks are very crucial. But now please do something. It is good that you do all of them, you pass, and you go home. Okay? So that is all I can say for now until I meet you again when I will be called to duty. So thank you all, unless if there is someone else, I can ask Esbon to maybe close with the word of prayer. Anyone who has something to say?
I have a question. Just, I don't know if I missed. When are we having the next session? After a
It is
month?
on Saturday.
Oh, it's still there every Saturday, right?
Yeah, every Saturday, but it will be a different unit, so maybe you will get a different facilitator.
Oh, no problem. No problem. Thank you.
Yes.
Thank you.
Thank you. Yes, Onyango George.
Yes,
Onyango,
thank you, Mr. Angelo, for the fruitful discussion. I have a concern because this is one of the serious groups that I've ever participated since the inception. Like for in orals, it helped me a lot. I was asking for that if you can please schedule other time other than Saturday. We have Saturday and other days for discussion. We are always ready.
Okay, that is a suggestion I can take to our leader. However, if majority of you could suggest maybe in the group, then we can see how we can put in our time and maybe say maybe we can do it twice a week. So it is something that we can consider. Okay?
Yes, yes.
You can make that suggestion in our group. Anyone else? Okay, Esbon, you can pray. We conclude, please.
Okay, thank you. Let us believe and pray. Lord, we come before you this evening. We thank you for the gift of life. I thank you for the team of facilitators with a good intention to have knowledge shared and imparted. Lord, we thank you for the team of students, the current students at the Kenya School of Law, who are devoted to have the search for knowledge in preparation for the exams. I pray for energy. I pray for strength. I pray for just good and really everything they need right now for the purpose of the exam. May they never lose hope. May they only know the success that will come up their way in few months' time. I pray this through Christ our Lord. Amen. In the name of the Father, the Son, and the Holy Spirit. Amen.
Amen.
Good night to you all.
Amen.
And guys,
Amen.
Alice or Joylene Otieno, please share the recording in the group. Thank you. And see you guys again next.